particularly through if we trace section 53 of IPC, which laid down the types of punishment that IPC had in itself. Now, as we know that there was a massive overhaul of criminal justice system in India in the year of 2023, tracing to 2024, whereby the colonial legislations of criminal justice system were replaced by new acts. That is, Code of Criminal Procedure of 1973 was replaced by Bharatiya Nagrik Suraksha Sanhita 2023. The Indian Evidence Act of 1872 was replaced by Bharatiya Sakshi Adhiniyam 2023, and the Indian Penal Code of 1860 was replaced by Bharatiya Nyaya Sanhita 2023. Now, for this purpose, if we go by the provisions of BNS, I would be referring to Bharatiya Nyaya Sanhita as BNS. Uh, we see that BNS aims to modernize the legal framework as it incorporates the principles of justice and aligns it with international standards, whereby more emphasis is put on retribution and in a reformation and rehabilitation of the offender instead of retribution. It emphasizes on reconciliation and restoration rather than merely meting out punishment to the offender. It has also helped us to decolonize a legal system wherein we have moved towards integrating the indigenous justice practices that we had instead of following a colonial era law, with whereby the main focus of the laws that the British government imposed on us was to, because they wanted control, because they wanted to control the population and to keep their supremacy over the general indigenous population of the country, which can be seen because the offense of sedition that the IPC had, it was to suppress dissent, whereas BNS has removed the particular offense of sedition and instead has incorporated in itself crimes like terrorism. Terrorism was made an offense, and instead of sedition, sovereignty of the nation was given importance. So we can see that with the introduction of BNS, which was enacted on December 25, 2023, and became effective from July 1st, 2024, it has aligned to the contemporary Indian values, which focuses on justice, fairness, and social harmony. The major key changes we can see is, as I said, the insertion of crime as an offense. There have been clearer definitive definitions, like the definition, the difference between murder and culpable homicide not amounting to murder. That definition has made clear and distinct. There has been introduction of new form of punishment, which is community service. Other Another new offenses which have been included relate to organized crimes and mob lynching, and keeping the contemporary societal restoration in mind. The offenses related to technological and AI related crimes have been included. This shows that BNS has tried to keep a balance between punitive measures and rehabilitation measures, whereby stricter penalties have been imposed for hate speech and fake news. However, the petty offenses like petty theft, they have been awarded the punishment of community service. This shows a shifting focus, whereby the focus is kept on victim centric approach, whereby emphasis on victim compensation and rehabilitation is put. Provisions as to witness protection and support services are being incorporated, and the legal fraternity also thinks that this will allow for a faster trials and it will reduce the justice delivery system. If we see the modernization and technological integration, we could see that BNS has incorporated in itself the use of digital evidence and forensic science investigations. FIRs are been allowed. There have been allowed e-filing of FIRs and online case management systems. This is done in order to promote transparency and accountability in law enforcement. For this could be seen as example of use of facial recognition technology in identifying the repeat offenders in order to keep a tab on recidivism. Next, if we go by what was the need for the reform, we can see that IPC was a bulky legislation and it did not cover the modern social realities. There was prolonged litigation due to procedural difficulties, the technological driven crime were not properly addressed, and there were inadequate mechanisms which to deal with victim protection and rehabilitation. Now, how BNS have solved it, we could see the features of BNS whereby there has been a structural transformation where the number of provision have been reduced from 511 to 358. BNS has also imposed stricter punishments for serious crimes. It has also included technological offenses, and it has also have alternative form of punishment as I've already discussed. This takes us from retribution to restoration, whereby IPC focused on utilitarian principles and kept emphasis on deterrence. BNS is a hybrid model whereby retribution is balanced with individual rehabilitation because it also addresses recidivism, but it also looks for provides for alternative form of punishment. Now, the implementation of these alternative form of punishment can be seen through BNS, whereby it has provisions for victim offender mediation boards. There are community impact statements and skill development sentencing. When we talk about prohibition
Uh,
and
Bhanu, your time is going up, so please go to the conclusion directly.
okay, sure. Now, even when we see so many positive things about BNS, there are certain limitations which come with it, certain challenges that it fails to still address. That is, there is still some ambiguity and gap left. There is challenging challenges as to implementation because if we are overhauling the whole criminal justice system, it is also to be seen that the whole working the law enforcement agencies, the judges, they all have to learn the law again, and to implement it again it will take too much time, too much training which is not being properly provided. And there are also some concerns as to digital rights and privacy. And even when we have included the restorative justice model, the restorative justice model is incomplete in itself. And what we fail to analyze here is the economic effect of this. When we talk about challenges, we have also to see if the new legislation is comparative to the economic challenges. We have no data as to conclude how BNS how it is going to have the financial implication when we talk about the technological upgrades. Because if we talk about e-filing of FIRs, if we talk about digital facial recognition and all that, the digital crime enforcement will need financial assistance. We don't know what implication it would have. There is no proper cost benefit analysis of implementing community service as instead of incarceration. Also, we have to see the economic burden of retaining this entire justice workforce.
Okay, Bhanu, please, we are getting late. So
Yes,
please conclude.
yes. By concluding, I would just like to say that BNS is just a beginning. It's not a culmination of legal evolution. We still need comprehensive capacity building. We need proper resource allocation to strengthen the accountability mechanisms that the BNS has started. With this, I would like to add.
Okay,
Are there any questions I could address?
okay, so it's finished.
Yes, sir. Thank you so much.
Okay, so Bhanu put her views on the modern restoration of Indian criminal laws. And Professor Satyaprakash sir, would you like to say something on this topic, on this paper? Hello, hello.
Yes, sir.
No, I'm talking to Professor Satyaprakash,
I
sir.
Okay, okay,
okay.
sir.
I will speak in the end.
Okay, sir. Thank you very much. So, should we call next presenter, Mr. What's his name? Mr. Uh, Sumit, Dr. Sumit, Dr.
Good
Sumit.
afternoon, sir.
Advocate
Actually, Sumit,
Dr. Vidya.
no, sir. Actually, Sumit has some physical problem to sit on the chair,
Okay. Okay.
so
Uh,
he
Good
refused to
afternoon, sir.
present himself. Okay, Sumit. Let's start.
Sorry for breaking the queue, sir. Due to an accident, I can't sit for long.
No
So
problem.
that's why.
Get well soon.
Thank you, sir.
Get well
Thank you,
soon.
sir. So good afternoon to one and all present. My
Yeah.
topic for today's presentation is strengthening victim-centric approaches in criminal justice,
Mhm.
policies, practices, and future directions.
Mhm.
Now, before I start my topic, there are two small statements that before the modern legal system came into place, if I go back to the olden days, we had a system, especially in the villages, where people would sit and discuss amongst themselves and find a solution to the problem or to any crime that has happened. And secondly, if I see the current or our modern legal system, especially I'll talk about India, we have crores of pendency of cases taking 10 years, 20 years. In fact, there was a legacy case in which the judgment came after almost 100 years. Now, if this is the situation of the current modern legal system, where are we failing or are we going in the right direction? Now, having said this, I would use the term restorative justice because my topic says strengthening victim centric approach. So, what is this victim centric approach? So this restorative justice, it's a set of principles and practices that creates a different approach to deal with crime and its impact. Because currently what we see that in our legal system, how we are more focused on the offender. We see crime, anything that any offense as a crime against the state, and the state starts dealing with it as if something has happened against it, rather than seeing it as that the wrong has been done against the society. In this entire process, somewhere I feel that the victim is getting lost. What the victim has gone through, what is the victim's requirement, no one is talking about, right? So, this restorative justice practice works to address the dehumanization frequently experienced by the people in this criminal justice system, which instead of viewing a criminal act as a violation of a rule or statute, it seeks to address the relation of the people and the between the people, or it seeks to bring harmony between the uh, victim and the offender. So restorative justice, as I said, as it seeks to examine the harmful impact of a crime and then determine what can be done to repair that harm while holding the person who causes it accountable for his or her action. So accountability for the offender means accepting the responsibility and acting to repair the harm done. Having said this, what can be the better or best remedy for any wrong whereby the person who has committed the offense, the person who is the victim, the community setup in which they live, they are brought together and a discussion is allowed in a safe and secure environment that sit, discuss, fine. The person has committed an offense. The person feels that yes, he has done wrong and he is sorry, or he feels that yes, he shouldn't have done it, right? So there is a scope that yes, this person will improve. Now, rather than putting it into a traditional legal system whereby this case may drag on for years and years, what we do is we let them discuss and come to an amicable solution, right? If the victim is agreeing that okay, with a monetary compensation. The whatever wrong has happened can be compensated. Fine. If the victim agrees that okay, to some extent monetary compensation and to some extent punishment in the form of say imprisonment can do, right? So if that can be reached upon, what it will do, it will serve a wide purpose. First of all, the victim is getting what he or she actually wants. Second, the wrongdoer or the uh, criminal is also getting punished in one way or the other. Third, the pressure from the current legal system is getting reduced. If, say, for example, the same trial, if it goes on for 10, 20 years, if due to the consultation between the parties comes or happens within 6 months or a year, look at the justice that we are actually delivering, right? So having said this, so restorative justice, it is based on the principle that crime is a violation of people and relations. In restorative, we see it from the lens of people and relations rather than the current system where we see it as the state oriented, right? So crime, it hurts the individual victims, the offenders, and creates obligation to put things right. So simply what we are trying to do is we are trying to repair the harm, the relations that have been uh, impacted by the harm done. Right. The second most important part of it is that the victim and the community are the central or the focal point of the justice process. The state is merely a facilitator, which I always believe that the state should be a facilitator rather than the uh, whip wielding person, right? So what we are doing here is that the victim and the criminal and whatever the community, the friend, the family, they get involved here. They find to come to a solution, and then they approach the court that look, this is the solution that we have come to. Now, having said this, I don't say that yes, in every case it is possible. There are certain cases whereby the criminals are uh, quite hardened, or I'll say the degree of crime is quite uh, harsh. So, yes, I'm not saying that it can be applied in every situation, but in my opinion, majority of the cases can be sorted by the restorative method, right? So, this is what should be focused upon. Now, what happens in restorative? As I have said, we have served the basic purpose of delivering the justice as well as saving the time of the system. And we are also ensuring that the crime does not happen again. The victim is satisfied. The most important part is victim satisfaction. Because what happens in the traditional system that, okay, the case has gone to the court gives imprisonment to the criminal. Ultimately, what happens to the victim? Right. I'll tell you one small example. When the concept of fast track court had come, though I was a law student at that time, just a student, and we had gone to the court for a court visit, and then we were told that look, this fast track court system has come, and we will bring in speedy justice. And there was a case pertaining to 302 IPC was going on. Later on, we found, much after I completed my law, that after 7 years of trial in that fast track court, there was no conclusion to it. Now, which one is better? Whether this system or whether the other system whereby, if possible, the two parties come, sit together, find a solution, right? There, if the obviously if the perpetrator has remorse in him, and we deliver a justice system. Yes. So this is what like modern legal system has to think about like European countries, the Latin American countries, right? In fact, in America also, like they are more now focused into the restorative form of justice rather than the old British mindset of this deterrent theory, right? Though work has been done, like I don't say that it's very pure form of restorative, but in CRPC we had the concept of plea bargaining, right? Even in Bharatiya Nagrik Suraksha Adhiniyam we have the concept, right? But this needs to be made the more focal point, right? So to conclude, I would only say that looking into the Indian legal system, the amount of pendency we have, I think we are not delivering justice at all. Victims, in fact, like it is sad to say that people even don't want to approach the court. People see it as like the last thing that anyone would want to go, because the harsh reality is that once we go to the court, there's no one knows when where it ends, how long it will take to end. So if we can move to the restorative form of justice, whereby the legal luminaries, the academicians, we all can come together and find a better way out, train our people, like the old panchayat system. I don't say that it is also very perfect, because that is quite rudimentary, but if we can brainstorm on it, come up with a very trained and very established mechanism whereby all form of
हो गया ना
crimes
10 मिनट
can
हो
be
गए
sorted is the need of the hour, especially with the number of crime increase. Having said that,
Sumit, Sumit,
thank you
please,
very
please.
much, sir.
Okay, thank you very much, Sumit, for your
Thank
mind-blowing presentation. And now, Palak will introduce next presenter.
We will continue with the other author, Advocate Dr. Vidya Subramanian. I would like to invite you to present your topic, which is President of Border and Court in District God Craft University's Overseas Justice Law, Agenda Advocate Dr. Vidya Subramanian.
Dr. Vidya?
Hello.
Yes, welcome, Dr. Vidya.
I'm sorry, myself Jayashree. I'm a co-author with Dr. Vidya ma'am. So I'll be
Okay,
presenting on her behalf.
Jayasree.
Yes, sir.
Welcome, Jayasree.
Well,
Please,
hello, sir.
please start your presentation.
Okay. Can I share my screen?
Yes, please.
Yes, sir. 1 minute.
Do you want to say something?
I would like to share my screen.
All right, please.
Is my screen visible, sir?
Yeah,
Yes, sir.
yes,
Now is it visible, sir?
yes, it's visible for we all.
And it's is it fluctuating to next slide, sir? Just for confirmation.
No, it's not fluctuating. It's okay. Go ahead.
Now can you see,
Yeah.
sir?
Yes. You are not audible actually.
Sir,
Hello.
it's
I think
just a
connectivity is
minute.
not good.
Hello, sir. Yes, sir.
Yeah. Yeah, I'm
Just a
getting
minute,
you.
sir.
We are getting you.
Yes, sir. Now can you see my screen, sir?
Yeah,
So now
sure.
you can see my screen, sir.
Yeah. Dr. Vidya, Dr. Jayasri, we have some problem in connectivity. So please present your paper in
Sir.
don't
Good
share the
morning,
screen
everyone.
because there is a connectivity problem. So you can
Good
present your
morning,
paper.
everyone. I'll be presenting. I would like now. Okay, sir.
Hmm.
So I'll stop screen sharing and I'll just present
No
myself.
problem.
So myself, okay, I'll start with a quote like what was once law was not always right. The arc of progress demand we question not worship president by Michael Obama. In this paper, I will be talking about the president is not a burden on court. A court can always refer to a president. President is nothing but a previous decisions given by the Supreme Courts or the superior courts in a court pyramid. Whichever higher courts have given decisions, we normally follow it as a standard norm. But the norm which has been given is always have a gender specific favorability or gender discrimination. Normally, when we talk about equality or gender justice, we only focus on women and highlight and glorify women as women empowerment is not being given. My paper will be talking about the male abuses, the opposite side, the male abuses, male violences which has been undergone because of only supporting female or only giving protection to women in the society. It's not that the women are protected and male are the only persons violated or abused. Women also gets violated, but the point of focus is that victimization should be general. It should give all genders equally is what my paper will be focusing on, wherein we have seen a lot of case laws wherein we have seen there are normally a male victimization is never focused on. People always consider that male as being the dominant people or the male alpha male or they have the precedence or a myth that a male can never be a victim, they can only be a perpetrator in offense. They're always considered as being the person to inflict inflict the wrongdoings. But male can also be a victim as well. What will be focused here, where the presidents of the court also focus on saving only a women gender in the society, where the presidents fix on the role or the roles fixed on the gender clauses, and the precedents for not allowing for such decisions, which will create a burden on the society. As law also from the criminal law to civil law to constitutional law, all the laws focuses only on supporting women or protecting women gender. By overarch view, they may say that we are equal to everyone, giving equal right. But when it comes to gender issues pertaining to a woman standing opposite side for a gender or a justice to be delivered, the justice always goes in a favor of prejudicial mindset of supporting a female. From historical perspective, from the libertarian feminism wave to all the reports which has been submitted before the law commission or the precedents which has come or the decisions which has been delivered, even the 172 report commission which gave for a gender neutral laws, it has not been addressed properly. And the reason of gender bias is normally if the patriarchal mindset or the unreported cases of male abuse or the myth of incapability of man being abused or raped or the emasculation of manhood for which they don't report it as well from man's side. So the legislative precedents from the NAS Foundation cases take it for the case of same sexual offenses or the same sex marriage or the same consensual carnal intercourses between same sex homosexual men. The decisions which came initially, the NAS Foundation decision, where NAS Foundation was the government of NCT of Delhi, where they decriminalized section 377 previously in IPC, which says carnal intercourse between consenting men was not a crime, was held in this case, provided the decision was overturned by the president. This presidential decision was overturned in Suresh Kumar Kaushal versus NAS Foundation. They criminalized it again, and the decision became a burden. And then later on, when it was challenged, it was decriminalized in Navtej Singh Johar, was Union of India, where they currently has been said that it is not an offense to have a sexual intercourse between same sex, provided if it is with a consent, was held in Navteej Singh Johar case also. But then in the current BNS law, it has not been mentioned at all. There are recommendations given by the standing committee to add section or something similar to section 377 also. And similarly, in the case of state of Maharashtra versus Madhukar Narayan Madhikar case also, they held that a man can never be a victim. He can always be a perpetrator in male rape cases also. Similarly, in Gurmit Singh also, they said even if there is a male rape or anything, they held that even in they denied the possibility of male victim in Gurmit Singh case, said that sexual offense against women can only alone mentions a rape concept, and committed without her consent, that is the women's consent, is only forms under the rape territory clauses and not for male. And they held that it's very difficult to say whether male is raped or not. To make laws and have an evidentiary point of view was also highlighted in this case. Similarly, the male assault and violence cases were not recognized in the case versus state of Rajasthan also. And when that challenge, the case was giving some kind of recognition for the first time. They considered the point that man can also be assaulted and while violence can be inflicted, provided it was not classed as a rape loss under section 375 of IPC, but it was considered under 377 previously. But now BNS has not even given a consideration for the same under section 63 of normal rape laws, or any other special as unnatural offenses has not been quoted. Similarly, in the case of Napun Saxena versus Union of India also, they have held the same issues. And then in case Puttaswamy, they said it was that the in case Puttaswamy, they held the privacy laws to dissent live-in relationship as an individual person's autonomy. And the influences of the patriarchal mindset and precedence is prominently seen from various cases. In the maintenance cases, take it for women maintenance, if they claim under section 125 of IPC, take a Muslim women who claim maintenance, they created a law which they created a statute saying Muslim Women Protection of Rights Act in 2005, in which they said a Women Protection of Rights on Divorce Act 1986 was brought to invalidate a Supreme Court's decision to give a maintenance under Section 125 of IPC in Shah Banu Begum case. Similarly, in triple talaq cases of Shara Banu, it was held that pronouncing triple talaq by a man will amount him to be penalized, provided the same norms will not be applied for a Hindu or a Christian person if they go for a divorce laws. Just because they pronounce it, the pronouncement of abandonment clause was taken and they were criminalized on this concept. Similarly, in Narsappa case, the difference between a Hindu man and a Muslim man to classify for a bigamy was upheld, where a Muslim man can have a bigamy because the
Excuse
personal
me.
law protects him.
Is
Jayashree,
there
please conclude your paper.
Yes, sir.
Please conclude your
So,
opinion. Thank
okay,
you.
my opinion is that
is
according,
there
can I conclude, sir?
necessary?
No, nothing. You can just go ahead.
Yes, sir. So my recommendation of here in the paper, it was that according to Justice Radhakrishna's words, which I would like to uh, support with, it says that court ought to avoid the mindset of making a same mistake or going to the same cases, and should apply justice in a way that reflects the circumstance of a case rather than outdated precedences. As gender justice is important for men as well, is what I would like to mention in my paper.
Okay, Jayashree,
Yes, sir.
is it over?
Yes, sir.
Thank you very much your precious opinion on the
Thank you.
precedent.
Yes, sir.
So now we will go ahead with another author,
Yes,
and
sir.
Palak will introduce her. Sir Satyaprakash sir, do you want to say something?
No, it's all right.
Okay,
Please continue.
thank you very much, sir.
Continue with,
Thank you very much.
with other
Thank you very much, sir.
continuous. Okay.
Yeah. Now I would like to invite Miss Swasti. Hello everyone. With her paper
Thank
content,
you
I
for
get a presumption of
your
innocence.
absolute excellent
A shift towards a punitive state.
Now I would like to invite Ms.
Husband,
Swasti Jain to present her papers on the title of Presumption of Innocence in the Age of Criminal Law Reforms, a shift towards a punitive state.
Miss
Ms. Swasti
Swasti,
Jain,
Miss Swasti, are you present here?
ma'am, are you there?
Miss Swasti, I
Ms.
think Swasti is
Swasti
not
Jain,
present. So next,
I would like to
she's
invite
not
the
present.
next author, we
Swasti.
on the topic
Good
of
afternoon, sir. This is Nidhi. Am I audible?
okay.
Swasti, are you present here?
Yeah, you are audible, Nidhi.
Okay, sir. So, good afternoon to one and all present here. Today, I am author B. Nidhi, along with my co-authors Dheeraj.
Swasti.
Sir,
Yeah, please
am I
go
audible?
ahead.
This is Nidhi.
There is some connectivity.
Good afternoon, sir. Am I audible? This is Nidhi.
Swasti
Yeah,
Jain is not present. I would like to invite the
Nidhi,
next
go
author,
please continue.
Yes,
B.
sir.
Nidhi,
We are
Yes, sir.
listening you.
Yes,
on the
sir.
topic of the shifting
Yes, ma'am. Good afternoon to one and all present here.
I
Today,
think there is cross connecting something. There is problem in connectivity. Uh,
good afternoon, sir.
yes. Please. Welcome.
Yes.
Very good afternoon.
Good afternoon. Today, myself, Nidhi, author, and my along with my co-authors Dheeraj and Devan are going to present on the
Okay.
paper titled "Shifting Paradigms of Juvenile Justice in India from Traditional Practices to Contemporary Reforms." So, moving on with the introduction part. So I'll be comparing the pre and post constitutional laws on juvenile delinquents per se. The pre-constitutional laws subjected to juvenile justice are the Apprentices Act, which was the first act in accordance with juveniles per se, and that act it allowed courts to treat petty offences which is being committed by juveniles. And the next act was Reformative Schools Act, which focused on the children under 15 who had been sentenced to imprisonment to be sent to reformative homes, and followed by the Indian Jail Committee Act 1920, which was especially for establishing separate courts in order to try the juveniles. So these are the pre-constitutional laws subjected to the juvenile delinquents. So regarding the post constitutional law, it is the Juvenile Justice Act 2000, which was in accordance with the principles laid down in United Nations Convention for Rights of Children. There they introduced the welfare of the children, and also they introduced the term child in conflict with law for the first time. And moving on to the amendments which has been made in the present Juvenile Justice Act. So there is a slight amendment which is given for the role of a district magistrate. So the role of district magistrate was enhanced in this particular amendment which was made in the Juvenile Justice Act at present. That is, they were given power to issue adoption orders under Section 61 of the JJ Act, and also they were given power to evaluate the juvenile boards and schools which is laid down under this act. And when we compare this juvenile justice with the in par with the new criminal laws on juveniles, that is BNS and BNSS. So the section 20 and 21 of BNS, that is then IPC, now they have classified child under 7 years of age has not committed any of, if they have committed any offense, will be exempted from punishment. So the principle of Dolly Incapax was again introduced in BNS. That is there is no sort of change brought in this new criminal law bill. And the next BNS is section 480. It provides anticipatory bail for the child in conflict with law. So these are the two provisions which has been concentrating on juveniles when it comes to BNS and BNSS. So I've also compared with the NCRB stats at present. So at present, the as per the statistics of NCRB, states of Madhya Pradesh, Maharashtra, and Tamil Nadu are the top 5 states wherein the number of crimes committed by juveniles are high in number. And other thing is that when it comes to state wise, it is this. And when it comes to the overall increase of juveniles, 0.8% has been increased from the year of 2022 as per the latest stats. And moving on to the objective parts, so my paper, it focuses on 4 objectives. The first objective is to examine the legislation portraying for protection and prevention of juvenile delinquency. Second is to study the similarities and dissimilarities of juvenile justice system from past to present, which I've already enhanced before you. And the third is to recommend measures to break juvenile offenses. And fourth will be to know major challenges faced by the juveniles from getting proper justice. So my co-author Dheeraj will be explaining the analysis part alone. On to Dheeraj.
Good afternoon to one all present here. This is Dheeraj, and I'm here to explain about the analysis part. So under this, we have compared with our objectives. The first objective is to examine the legislations for protection and prevention of juvenile delinquency, in which we have compared it with gender, in which the male respondents feel that the legislations have been made, they're not sure about the legislations which have been made, and also they find lack of implementation and require certain efficiency to restructure juvenile delinquency. And the females have disagreed, stating that they have been tending to receive and witness more juvenile offenders in the later past. And also, figure 8 speaks about the private sector and unemployed. That is the based on the level of employment. The private sector respondents are neutral and they're not satisfied because they feel that the law is not up to the mark. And unemployed people, they disagree and they need for positive approach for juveniles. The second objectives is that the similarities and dissimilarities between the old laws and the new laws. As of this objective is concerned, there is no peculiar differences between the IPC as well as the recently amended Bharatiya Nyaya Sanhita. And the third objective is to recommend measures to break juvenile offenders, in which we have compared it with age, wherein there is too much flexibility. The 18 to 30 state that there is too much flexibility that would lead them to do such criminal activity more consciously and frequently. Ages 31 and 40 state that there is a lack of positive punishment, which nowadays people are feeling cool about it. And the fourth major challenge is that the major challenges faced by the juveniles from before getting proper justice, in which I have compared it with educational qualifications that state UG feel that lack of institutional support is there. And the PG students feel that there is a social stigma. That is, if a juvenile commits a crime, they are ready. They are not ready to accept them in the society. Now, my friend and co-author Mr. Devan will complete with the limitation and suggestions and conclusions.
Good afternoon to one and all present here. So I am Devan Chakravarti, the second co-author. So the major limitations we have faced in this particular research is that the sample frame, where we have conducted this research in a very small area, and the sample size is around 200, which is not at all conclusive to bring in a conclusive point regarding this particular topic. And the time constraint, we have very limited time regarding this particular research, and personal biases, as the respondents and as well as the researchers can have biases, can inadvertently influence study design and data interpretation and conclusions. So some of the suggestions we like to propose is that the Act's past reauthorizations include 4 safeguards for young people involved in state juvenile justice systems. The first is limit living, where they limit the number of kids who can live in the same place as adult offenders. The next is separation. When children and adults are accommodated in the same facility, there should be a separation of sight and sound. There should be a limitation of sight and sound. Which implies the kids can't stay in the cells near to adults. The next is detention, where a detention of status of violators is forbidden. And children who have violated laws primarily because of their age, such as curfew violations, are known as status offenders. So last to conclude is that, so again with a small hint of what is juvenile justice, the administration of justice for criminal cases includes a system known as juvenile justice. And this system was to put in place for children who are too young to held accountable for crimes. So next is the certain to conclude is that immediate attention is needed. Sir, am I audible?
Yes, yes, yes. Please go
So
ahead.
it's important to pay immediate attention to India's rising adolescent delinquency rate, and the main objective of this paper once again is said to examine the legislations portraying for protection and prevention of juvenile delinquency, and also to study the juvenile justice system from past to present. And the findings of this research clearly states that the legislations have not been made great progress in reforming the juvenile delinquents at present, and the major challenges faced by juvenile delinquent from getting proper justice is the lack of institutional support, and majority of them have an opinion that the Juvenile Justice Act 2000 is not adopting flexible sentencing. Rather, it is very rigid, and positive punishment is lacking at the present, which tend to have a negative impact over the child in conflict with the law. The next is rules and
Okay.
regulations. The next is
Conclude.
the
Dheeraj,
government.
Deven, please conclude. We have no time.
Yes, sir.
So many people are in the queue.
So that's to conclude with the final point. So this is because present juvenile laws do not have a deterrent effect on juveniles, and everyone has a responsibility to address the problem of juvenile delinquency, including society, parents, treatment centers, and so on. So this real world will be resolved quickly if all of these elements come into play. Thank you.
Okay. Thank you very much, Nidhi, Dheeraj, and Deven, for your nice and precious opinion on juvenile delinquency. And now we are calling to Palak. She will introduce next author. नहीं मैं करूं मैं करूं Hello, hello, am I audible? Chanjana, Elsa, Philip, and Ruva V. Hello,
Yes, sir.
Ruva. Oh,
Yes, sir.
okay. Are you ready?
Yes,
Okay,
sir.
sir.
I'm
Please start it.
I'll just share
Okay.
my screen, sir.
Yes, it's coming.
Yes, sir. So, good afternoon, everyone. Today I'm going to present on the title A Paradigm Shift of Sedition Law from Pre-Colonial India to the Present. So, sedition, it's a word we have all heard, often in political debates, courtrooms, and even on the news. But what does it really mean? Essentially, sedition refers to actions, speech, or behavior that incite rebellion against the government. It can be in the form of protest, public speeches, or even literature that questions or challenges the authority of the state. Sedition might seem like a modern concept, but it has existed for centuries. Back in the 16th century, England, kings and queens used sedition laws to punish people who spoke against them or tried to start revolts. Later, when the British ruled India, they brought these laws with them and used them to suppress Indians who spoke out for freedom. Even today, sedition law remain controversial. Governments say they are needed to maintain peace and security, but critics argue that they limit people's right to speak freely. This debate continues in democracies like India. So, in this presentation, I will explain how sedition laws have evolved over time, how the British used them in India, and how they continued after independence, and how the new Bharatiya Nyaya Sanhita has replaced the old IPC. So, coming to the next slide. Sedition in pre colonial India. So, even before the British introduced the sedition laws, Indian rulers had their own methods of dealing with opposition. So, during the Mauryan Empire, rulers like Chandragupta Maurya and Ashoka the Great maintained tight control over their vast kingdom. So, although Ashoka is remembered for his peaceful Dharma policies, his government used spies to track potential rebels. So, one of the earliest political examples of sedition laws is the Maurya Empire. So, during the Maurya Empire, rulers like Chandragupta Maurya and Ashoka the Great maintained tight control over their vast kingdom. So, although Ashoka is remembered for his peaceful Dharma policies, his government used spies to track potential rebels. So, one of the earliest political examples of sedition laws is the Maurya Empire. roles and maintain his authority. And when the British took control of India, things changed drastically. So in 1870, they introduced Section 124A of IPC in the colonial era, so which made it a crime to being hatred or disaffection towards the government. So the British had a clear motive to suppress the voices which demanding the government demanding the independence. So one of the earliest case I would like to talk about is Bal Gangadhar Tilak. So he was convicted and sentenced to jail as he was accused of sedition because of his writings in the newspaper Kesari, which the British claimed encouraged people to rise against the colonial rule. Then later in Nehrendu that Majumdar versus Emperor case, where the Federal Court of India it took a different approach. It held that that sedition should apply only where there is an actual incitement to violence or rebellion. So coming to the post-independence era, so after independence, one might have expected that sedition laws to disappear, but instead they remained under Section 124A of IPC. So, however, it placed some limitation on its misuse. So, one of the landmark case law I would like to talk about is Kedarnath Singh, where the court limited the sedition to the court upheld the law and it clarified that the sedition would only apply if the speech incited violence or any public disorder. So despite this ruling, sedition charge it continued to be filed over the years. If you see in case of Balwant Singh versus State of Punjab, the court held that mere slogans are not amount to seditions. So in recent cases like Vinod Dua versus Union of India, the court held the court stated that the criticism of government is protected. So in this case, a journalist was charged with sedition for criticizing the government's COVID-19 handling. The Supreme Court the Supreme Court reaffirmed that criticism of the government, no matter how harsh it is, it does not constitute sedition unless it incites violence or rebellion. Then in Disha Ravi, which has 2021 case, he arrested for sharing a toolkit supporting the farmer protest. So this case sparked debate on whether sedition was being used to curb activism. So coming to the shift from the IPC to BNS, so given all these developments, there have been growing calls to abolish or reform the sedition law. So in 2022, the Supreme Court put the law on hold, stating that no new sedition cases should be filed until the government re-examines the provision. So the government itself has proposed changes through the BNS, which is set to replace the IPC. But however, many argue that the new law retains similar provisions under a different name, which continues the risk of misuse. When we compare between IPC and BNS on sedition, so the issue with IPC sedition law is it has the broad language and vague terms like hatred and disaffection, which allowed the misuse against political dissenters and journalist activities to continue. But now in the BNS 2023, the provision for sedition the provision for sedition has been removed, and but a similar provision has been introduced under section 150 of BNS, which states that acts endangering sovereignty, unity and integrity of India. So, with all this, I would tell that while the government claims that the new law is narrower in scope, but many legal experts they still argue that Section 150 of BNS still allows the suppression of free speech just under different wordings. The concern remains whether this will continue to be used as a political tool rather than necessary security measures. So, to conclude, sedition in India it has evolved from a colonial era of repression to a legal provision in modern democracy. The courts also have played a crucial role in defining its limits, but its continued use remains controversial till now. So, as India moves forward, the real question is whether sedition laws should be amended, replaced, or abolished together. For now, the sedition debate is far from over. Thank you. Hello.
Uh, Hello, Harisha Sivan,
Yes, sir.
are you there?
Yes, yes.
Harisha,
Yes, sir. Hello.
so are you ready to present?
Yes, sir.
Okay, okay, please.
Okay.
Please, please.
Good afternoon, everyone. I'll be presenting my paper along with my co-author Alina AS on the topic enhancing victim-centric approach in criminal justice. For too long, the law has been centered its attention on the rights of the criminal than that of the victims of the crime. So it is high time to reverse this trend. The Indian criminal justice system, like any other system, has a historically been characterized by an adversarial approach that prioritizes the prosecution of offenders over the rights and well-beings of the of crime victims. So India's criminal justice system is a perpetrator centric, which focuses on the deterrence, punishments, and the rights of the accused rather than the victim centric approach, which aims for the empowerment of the and rights of the victim. This is because the foundation of the Indian criminal justice system is based on the retributive justice and not on the restorative justice. When we are saying retributive justice, it is more like giving up, focusing on giving punishment to the offender on the basis of what the victim has lost. And in so rather than focusing on retributive justice, the law should focus on more on restorative justice, which helps to know the root cause of the crime and promotes the healing process. And rather than it is not based on just a it is not just based on punishment based approach. So, our criminal justice system have come a long way to the present victim-centric statutes. The consequences of the crimes are now, as we know, it is multifaceted, which include physical, psychological, and financial dimensions. And the impact is not only on the victim, but on the society and the people who are around the victims also. So the effects like the victims themselves are also affected, and it has a far reaching impact on the social circles too. So immediate family members and close relatives often find themselves emotionally and financially affected by the procedures. The communities and neighborhoods are also affected by the crime, particularly if it is a violent and very violent or disruptive crimes. The sense of safety within the community can be severely compromised when a crime happens. So this leads to a decrease in the quality of the life of the people, who like people get fear that they will also be like attacked or get attacked in the same way. For example, when a local store is robbed, or or a home is evaded, the people in the neighbor may also experience the same kind of fear and anxiety. So this inequity has raised numerous challenges that we require in-depth examination for the protection of the and empowerment of the victims, as it should play an integral role in the criminal justice system. To effectively explore this proposition, we should know that what is the necessity of victims, like why the victims should be like victim centric approach should be there. So in historical development, we see that there is a difference in the criminal justice system. Earlier, when a crime is being committed, we see that most of the offender, it is a offender centric, like offender centric crime, in which the main focus is on the on punishing the offender rather than it should be on the victim's right. Traditionally, the criminal justice system centered around the prosecution of offenders with a limited regard to the aftermath of the crime that is on the victim. How in the recent decade there has been a growing recognition that victims deserve more than just being a bystander in the criminal procedures. So, coming to emergence of restorative justice practice, another noteworthy development within the victim jurisprudence is the integration of restorative justice practice. This approach emphasize dialogue and reconciliation between victims offenders in the community. So restorative justice recognizes that traditional criminal justice system can fall short in addressing victims emotional and psychological needs. By fostering communication and understanding, restorative practices seek to provide victims more with a sense of closure and empowerment while holding offenders accountable to their actions. As victim jurisprudence continues to evolve, it reflects a broader societal recognition of the importance of placing victim at the center of the legal process. Now, my co-author will continue the remaining topics. So, I am moving I'm handing over this to Alina S.
Good afternoon. So I'm going to talk about a holistic approach. The Indian criminal justice system has now dissipated with introducing the new criminal law, Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshi Act. The new law recognizes the right of the victim, including the participatory right of the victim. The rights recognized are participatory right under Section 360 of the BNSS, the right to information under Section 173 and 193 and 230 of BNS, and the right to compensation. So, what is right to participation? Most important aspect of this right is the concept of zero FIRs, which means the victims are allowed to file complaints in any police station, irrespective of the jurisdiction where the offense were committed, which stamps out the hurdles faced by the victims. Another important aspect is the EFIR. So, what is a zero FIR? Is a provision under the BNSS 2023 that allows a person to register a first information about a cognizable offense. It is provided irrespective of the area where the offense is committed. It allows people to file a FIR online without having to visit the police station in person. The EFIR system is designed to be efficient as it eliminates the need for people to travel to a police station and wait in a long line of queue to file a complaint. So the next one is the right to information which is given to the victim. The inclusion of the victim in every aspect of the proceedings in a notable characteristics of which is in our new BNSS. So Section 360 mandates that no court shall allow withdrawal from a prosecution without hearing the victim of the case. So Section 193 Clause 3 states that the police officer has the obligation to inform the process of the investigation within a limited period of 90 days. Thus, granting information to the victims is guaranteed under the provision of the Act. The next one is right to transparency. So, the right to transparency, which is given to the victim, is an exclusive factor of transparency in the matter of investigation and other proceedings. This right is assured by the granting police reports, FIR, and witness statements at every stages of investigation and trial. So next one is right to protection. So section 65 and 70 of the Bharatiya Nyaya Sanhita Act 2023 dealing with medical expenses and rehabilitation of the victims, and states that fines imposed shall be paid to the victim. Next one is section 176 of the BNSS highlights that the police officer shall record the statement of the victim of rape shall be conducted in a place of her residence or her choice in the presence of parents or near relatives or any other social workers of the locality. The provision of BNS also seem more strident in dealing with offences. The law aims to protect the victim to the most. Uh, Thus, the new law guarantees various rights to the victim, and this is considered as a paradigm shift of the victim-centric approach in India. The access to the victim is also ensured. The compensatory jurisprudence in India is still evolving and lacks specific legislation. However, we have various provisions in statutes that grant compensation to the victims of the crime, and the Indian Constitution award compensation for wrongful imprisonment, custodial death, and torture under Article 21 of the Indian Constitution. Since 2009, the central government directs every state to formulate a compensation scheme for the victims who suffer injury or loss. Accordingly, the participatory and compensatory right of the victim has been secured. Notwithstanding these new reforms, the new criminal so I would like to conclude my topic. So the speculation behind the introduction of new criminal law is to ensure victim-centric reform, to deliver swift and timely justice, and to have a transformative impact by replacing the core of a colonial mindset and its law. So I would like to say that the BNS has done a lot of work for the victim-centric approach, but it can still improve a lot in many cases. So thank you so much for having me and Hadisha today.
Thank you. Thank you very much, Harisha and Elena. Hello.
Thank you, sir.
Actually, in my opinion, we all are made by the nature, and nature's made is always beautiful. So we have to show our faces at least during presentation, if you don't mind. So now next presenter is
I would like to invite Mrs. Susan S. Anjan in her co-author, Amrita Gupta.
आवाज नहीं जा रही है तुम्हारी आवाज नहीं जा रही है तुम्हारी आवाज नहीं जा रही है No, no. Hello. No. आ रही है बोल नहीं नहीं आ रही है No. बोल बोल पलक पलक please introduce next
If
sorry
Swati Jain is
वो
available, we can take up Swati Jain. If Swasti Jain is available,
uh,
if not, then
Swasti Jain is not available, sir.
for Sushant.
Now
Jain
Sushant
will
is
go.
Anchan and Namrata Gupta.
Yeah.
Sushant.
Yes, sir.
Sushant.
We'll start with the presentation.
Namrata or Sushant?
Yes, sir.
Okay,
I'm Namrata, and then my
Welcome,
co-author will
Namrata.
speak after I'm done. Thank you, sir. Good afternoon to our respected chairperson, Professor Satya Prakash, and our co-chairperson, Dr. Vivekant, and the student coordinators. I am Namrata Gupta, and alongside Mr. Sushant S. Anchan from Thakur Ramnaran College of Law, affiliated with Mumbai University, I'm truly honored to present our research on the topic From Penal Code to Nyaya Sanhita, a critical study of the Indian legislative shift in the criminal law. We will be taking approximately 19 minutes to present our findings and insights on this significant transformation in the Indian criminal justice system. On July 1st, 2024, India witnessed a historic change. The 160-year-old Indian Penal Code, which was introduced during the British rule, was officially replaced by the Bharati Nyaya Sanhita (BNS) 2023. To provide a quick background, the IPC was initially drafted by the First Law Commission under the chairmanship of Thomas Macaulay in 1837. It was later refined and finally enacted in the governance in 1860. Despite its utility over the years, it was a product of the Victorian thought and colonial governance. Post-independence attempts were made to the reform the code, most notably through the Law Commission's 42nd report and the Indian Penal Code Amendment Bill 1972, which was reintroduced in 1978. However, due to the disagreements and political changes, those reforms were never materialized. Nearly 5 decades later, the Bharati Nyaya Sanhita replaced the IPC by removing 19 sections and adding 10 new sections. It modifies new offenses, sentence durations, and increases penalties, especially for contemporary issues like cybercrime and terrorism. The Indian Penal Code, enacted in 1860, has been amended more than 75 times. In our research, we have focused on 7 core themes that reflect the scale and depth of this transformation. First, the reorganization of the statutory chapters. Second, we will look at the decolonial reforms and the shift away from the Victorian jurisprudence. The IPC, though effective in parts, was never designed with the Indian society in mind, and it will delve into the legislative mind behind this reform. Third, there is a transformation in the punishment methods. While the IPC predominantly relied on the imprisonments and fines, the BNS reintroduces alternative punishments like community service. These reforms are in line with the idea of reformative justice, aiming to rehabilitate rather than merely punish offenders. Fourth, the BNS takes important steps in addressing modern crimes. Crimes like cyber fraud, terrorism, and organized crime were either vaguely addressed or completely absent in the Indian Penal Code. The BNS fills these gaps by reintroducing specific provisions that deals with these issues direct head to head. Fifth, we explore sexual offenses against women. The code strengthens legal protection for women with updated definitions, enhanced penalties, and a more victim sensitive approach. Sixth, We delve into the offences against children. The BNS includes stronger provisions for the protection of the children in the society. Lastly, we focus on the inclusion of mob lynching and organized crime as a standalone offences. This is a landmark development as these crimes, though frequent and serious, were not earlier codified in the Indian Penal Code. With this, I now invite Mr. Sushant Sanchan to proceed with the next part of our presentation.
Good afternoon to the esteemed
Hello,
dignitaries. Am I audible?
Sushant. Welcome.
Yes, sir. Yes, sir. Thank you so much, sir. So now I would like to proceed with the our next slides. So decolonization reforms and a shift from Victorian jurisprudence. With the reforms made in the Bharatiya Nyaya Sanhita, which has taken a shift from Victorian jurisprudence, the name of the legislation itself signifies the intent and the purpose of the legislators behind its enactment. In this case, the objective appears to ensure nyaya to the victim, which means the justice to the society and to the victim, and also to the first time offenders who commit petty crimes. Well, this seems like a minor alteration, but, but it changed the entire perspective towards the justice delivery system in India. In order to achieve above-mentioned objectives, a number of major as well as minor changes in the delivery system has been changed, such as we have introduced the removal of all references made to Her Majesty, Queen, British India, British calendar, etc., to major reforms such as removal of offences relating to sedition, adultery, homosexuality, attempt to suicide, etc. Coming to the next slide, the transformation in the punishment methods. One of the most awaited reforms in the BNS was the realm of the punishment. The major change in the domain of the punishment has been identified, which includes the first, the introduction of community service as a form of punishment under Section 4, subsection F of the Bharatiya Nyaya Sanhita. But there are significant loopholes in this section. Firstly, what constitutes as a community service has not been defined in this section. Secondly, the term for which a sentence of community service may be legally extended has not been mentioned in this section. However, this loophole can bring a huge challenge to the judiciary system while giving the punishment of a community services. Secondly, more mandatory minimum punishments and longer imprisonment terms and increase in amounts of fine as well as expanded scope of death penalties have been seen in the provisions of the BNSS. The inclusion of community service in 6 offences reflects a shift towards the reformative justice in the Bharatiya Nyaya Sanhita. Next, addressing modern crimes with new offences. The defense of duress under Section 32 of BNS provides the general defense for duress by threats. It is a clear reproduction of Section 94 of IPC. It exempts individuals who commit an offense, excluding murder and offenses against the state, which are punishable with death, and when acting under the threat of immediate death. Such a formal and pedantic approach fails to give an full effect to rationale behind enacting the said defense. In the practice, it may be challenged for being arbitrary, irrational, and unjustified in its scope. Secondly, the organized crime. It is defined under Section 111 of BNS. While the government aims to effectively combat through deterrent punishment under this section, but the absence of supplementary procedural and evidentiary provisions such as special courts, investigative powers, witness protection, and special public prosecutors, as well as evidentiary rules, presumptions, etc., lacks the special legislation to deal with the organized crime, will face insurmountable challenges in successful prosecution of offence penalized under Section 111. Consequently, such states may struggle with the effective prosecution under Section 111, whereas state with special laws will continue relying on them. This make a standalone enactment of Section 111 largely ineffective in practice, such as in Maharashtra, the Makoka Act, which is for the Maharashtra Organized Crime Act. It can be it will be ineffective if section 1111 of the BNS comes into the existence, because both the provisions have some or the other loopholes in it. Recasting of the sedition laws. The prima facie section 150 of BNS seems to introduce four major changes in the definition of the offense of sedition under the IPC, namely section 124 of IPC. It expresses stipulates the mens rea required to commit the offense by using the word purposely or knowingly. It expands the means by which the said offense may be committed by reference to electronic communication and the provisions of financial support. It completes alters the description of the prohibited actions and the object to which they were directed, and it enhances the minimum term of imprisonment avoidable thereunder from 3 years to 7 years. This is a clear change of just the name of the provisions, but the definition and all the things of the sedition section 124A of IPC has been put into section 150 of the BNS. Coming next to the offenses against women, which is defined under section 63 to 99 of BNS, and have been given over the other have been given presides over the others. Also, the offense against women and children were earlier scattered and have been consolidated in the chapter 5 of the BNS. Under this chapter, exception 2 to 63 of BNS provides just just 2 minutes. I'll just conclude it. BNS provides the sexual intercourse or sexual acts by a man with his own wife. The wife not being less than 18 years of age is not rape. The age limit was 15 years in IPC, so the marital rape is not still a crime, but the age of the wife for such an act to be considered rape has been reduced. Similarly, Section 69 is one of the pivotal provision which has been added in the BNS, which penalizes the act of sexual intercourse with a woman by deceitful means. It specifically mentions that such an act is done by deceitful means or by making promise to marry a woman without intention of fulfilling the same. It shall amount to, read strangely, the explanation through which the section states that deceitful means shall include false promise of employment or promotion or marrying by suppressing the identity. This creates a backlash to this provision, as it clearly states that if the deceitful means that false promise of employment or promotion to a woman, which brings an backlash to this provision. And as a time constraint is there in this session, I would like to conclude. And so offenses against children can be seen, which is also consolidated in Chapter 5, which was already scattered in IPC. So hiring or employing an child for prostitution, and the minimum year of 7 years was in the IPC, and it has made to a 10 years. And the prostitution laws which have been mentioned in B. And coming to next slide, which is the mob lynching. For the first time, Section 102, Subclause 2 and Section 117 of BNS specifically penalize the mob lynching and grievous hurt caused by mob lynching. But there are also loopholes in this section, because the word religion has not been mentioned in this section, which which gives a loophole in this section, as the major mob lynching cases are of the religious matters, and the word religion has been not mentioned in this section. However, the absence of religion as an explicit ground is unjustifiable given its role in many mob lynching cases. And coming to the conclusions, there are total 20 chapters in BNS, and IPC had 23 compared to IPC. And currently there are 358 sections in BNS, which was priorly 511 in IPC, and total 19 sections have been removed from the IPC, and currently the BNS has 358 sections. So concluding our presentation, we would like to emphasize that the substantive changes brought by the Bharatiya Nyaya Sanhita ultimately remains considerable, but confusion regarding the practical implication and implementation of the laws, especially with the change in the age-old schemes and chronological of the section, it is only the matter of time which will determine the success of BNS. Additionally, the introduction of community service as a punishment further demonstrate the shift from deterrence to reformative approach to the punishment, which was never an aim of British Raj. With that, I conclude my presentation. Thank you so much.
Thank you, Namrata and Shushant, for your tremendous presentation. And we have much more to go. So now,
Now I would like to call Priyanka Bose and her co-author Ms. Ryder on the topic of fruit of the poisonous trees. Doctrine, should India take a bite?
Hello, am I audible? Am I audible?
Yes, yes, please continue.
All right. A very good afternoon to our chair, Professor Satya Prakash, and our co-chair, Dr. Vivek Kant, and everyone present here. My name is Priyanka Bose, and I'm a third-year BLLB student at IIM Law School, Gurugram, and I have along with me my co-author, Rhythm, a first-year BLLB student at IIM Law School, Gurugram. First of all, it is an absolute honor to be presenting our paper here today. It is titled Fruit of the Poisonous Tree Doctrine, Should India Take a Bite? And it examines the admissibility of illegally obtained evidence in India, an issue that I believe sits at the intersection of constitutional morality and criminal justice. My co-author will be explaining research methodology and the objective of our study.
This paper adopts a comparative doctrinal approach, analyzing case laws, statutory frameworks, and scholarly reports from India and other jurisdictions such as the United States, United Kingdom, Canada, South Africa, and the European Union. The aim was to evaluate how different legal systems treat illegally obtained evidence and to assess the relevance of these approaches in the Indian context. Key judgments, Law Commission reports, and international conventions were critically examined to understand the evolving relationship between the privacy rights and evidentiary standards. Now, we'll move on to chapter analysis with my co author taking the lead.
With the context in mind, I'll proceed on to the core chapters of the paper. This paper begins with a simple but critical question in the introduction. Can the state violate fundamental rights in the name of justice and still rely on the fruits of that violation in court? This issue, central to India's approach to illegally obtained evidences, touches upon all the key themes that we've explored ahead in this paper. The evolution of privacy as a fundamental right, the tension between law enforcement and due process, the comparative jurisprudence on exclusion, and the long ignored recommendations of the 94th Law Commission report. We move on to chapter 2 from here, which takes us to the heart of the Indian evidence law, which is the test of relevancy. In India, the admissibility of evidence does not hinge on how it was obtained. It is governed by the test of relevancy as defined under Section 3 of the newly enacted Bharatiya Sakshya Adhiniyam 2023. That is, if a fact in question is connected to a fact in issue, it is considered to be relevant and therefore admissible. This principle has been repeatedly upheld by our courts, including judgments such as R.M. Malkani and Puran Mal, where the Supreme Court has made it clear illegality in procurement does not make evidence inadmissible unless it is clearly prejudicial or unfair. Even procedural safeguards like those under Section 185 of the Bharatiya Nagarik Suraksha Sanhita of 2023 are treated as merely flexible. Therefore, illegal searches and seizures are often seen as technical lapses in our country and not constitutional violations. So, what we see here is a system that prioritizes efficiency and conviction over due process. That being said, there have been isolated judicial moments of caution. For example, in the case of Bhai Radha versus State of Gujarat, the court observed that although illegally obtained evidence is admissible, it must be scrutinized more carefully, especially if it could harm the accused. But what we see, the general trend in Indian jurisprudence is that it clearly leans towards admissibility by relevance. So, this chapter of my paper sets the foundation for the very next chapters, where we explore how this position sits uneasily with the constitutional right to privacy, especially post the case Puttaswamy judgment. Chapter 3 of my paper talks about the contours of privacy in the Indian jurisprudence. Privacy, as we know it today, is not just about secrecy alone. It is a shield against state intrusion. And while our constitution did not originally mention privacy, the jurisprudence around it has evolved dramatically over the years.
Let's talk about early cases like MP Sharma and Singh, which outright denied privacy as a fundamental right. Therefore, the state's power of surveillance and search were considered constitutionally valid. But this shifted fundamentally post the case Puttaswamy versus Union of India, where a nine-judge bench unanimously recognized this privacy as an intrinsic part of Article 21, tying it not just to dignity, but liberty and the structure of constitutional morality. And since then, what I believe is we have seen a ripple effect. Cases like Navtej Singh Johar and Joseph Shine have expanded the scope of privacy, reinforcing autonomy and freedom of choice. This right has become especially urgent to us in this digital age. And the benchmark for assessing such intrusions have also been laid down in the landmark case of Maneka Gandhi versus Union of India, where the triple test of legality, fairness, and non arbitrariness was laid down. So we come back to our previous question. If we recognize privacy as a core constitutional value, how can we allow illegally obtained evidence, often procured through surveillance and violations, to still be admissible in court? My co author will take on for the next few chapters.
Now, the chapter 4 deals with India's legal framework on surveillance and searches which resembles a tangled web. Multiple laws grant interception powers, but none offer a clear constitutional umbrella against misuse. For example, take Section 5, subsection 2 of the Telegraph Act 1885. It lets the government taps communications during public emergencies. Rule 419A tries to add accountability, but in reality, these rules are more observed in the breach than in the practice. Different laws like the Income Tax Act, NDPS Act, and the Customs Act allow searches and seizures, yet there is no consistent rule on whether illegally obtained evidence should be accepted. Tax code says yes more easily, while NDPS courts take a stricter view, especially when individual rights are violated. This inconsistency highlights a bigger problem. India lacks a uniform constitutional safeguard, unlike countries with firm exclusionary rules. The 94th Law Commission report tried to fix this, suggesting a new section 166A in the erstwhile Evidence Act to give judges discretion to reject improperly obtained evidence. But that idea never left the drafting table. So, right now, admissibility of evidence in India depends more on judicial mood than legal clarity. The law is caught in a constant tug of war between efficiency and fairness. Chapter 5 deals with from how wiretaps to secret recordings. Indian courts have long debated. Should justice rely on evidence gathered in the shadows? With privacy now a fundamental right, the tension between surveillance and fairness is sharper than ever. Earlier courts prioritized relevance over legality. In R.M. Malkani and Puranmal, illegally obtained evidence was still admitted if it wasn't unfair to the accused, but exceptions emerged. Baldev Singh rejected evidence violating the NDPS safeguards, and the case of Selvi barred forced narco analysis. Then came the Puttaswamy judgment in 2017, which recognized privacy under Article 21 and laying down the legality, necessity, and proportionality test. Post the Puttaswamy judgment as well, courts started shifting. In the case of Vineet Kumar, the court struck down unlawful phone taps, and in the case of Deepti Kapoor, it allowed private evidence in family disputes, prioritizing a fair trial. What is the bottom line then? The bottom line is the Indian courts are slowly moving from whatever works to what's right. The chapter 6 of the paper deals with the jurisdictional variations in the admissibility of illegally obtained evidences. While India has no fixed exclusionary rule, countries like the US have a strict rule under the Fourth Amendment. The UK and Canada apply discretionary or balancing tests, and South Africa has a constitutional exclusionary provision. These systems recognize the fairness and the rule of law should not be compromised even in the pursuit of justice. Now, my co-author will take on from the 7th chapter.
Due to paucity of time, I'll just move on to the recommendations. Chapter 7 of the paper presents the way forward in context of the newly enacted Bharatiya Sakshya Adhiniyam, along with the 94th Law Commission report, which aims to modernize India's evidentiary framework. particularly regarding digital evidence. However, what we notice again is that it lacks explicit safeguards for unlawfully obtained evidences. In response, we have proposed a comprehensive rights respecting clause. This proposed section adopts a multi factor test requiring courts to evaluate whether such evidence would 1. Render the trial unfair, 2. Encourage unlawful law enforcement conduct, or 3. Undermine the public trust in the judiciary itself. More importantly, it mandates the exclusion of evidence obtained in flagrant violation of Part 3 of our Constitution, which guarantees to us fundamental rights, unless exceptional circumstances exist. It explicitly also defines what illegal means, encompassing unauthorized surveillance, custodial coercion, hacking, and biometric data theft. It also further extends protection to victims of such violations, enabling them to seek remedies such as compensation or disciplinary action. Overall, this comprehensive legislation makes us future ready. My co author will now just present the conclusion to this presentation.
As the right to privacy becomes a defining feature of India's constitutional landscape, it's clear that how evidence is obtained can no longer be ignored. The judgments in Vineet Kumar and Jatinder Pal Singh mark an important shift towards accountability, judicial oversight, and the protection of individual rights. Introducing a discretionary exclusionary rule aligned with global best practices can help India strike a fair balance between justice and due process. After all, the strength of a legal system lies not just in uncovering the truth, but in ensuring it's done the right way. So, the question remains, should the truth always prevail, even when the path to it violates the law? Thank you.
Thank you so much. It was a pleasure presenting before you all.
Thank you, Rhythm and Priyanka. Thank your precious opinion on this matter. Now we are proceeding to Palak.
Now, I would like to invite the next author, Priyanka Kumari, and her co-author, Dr. Bhrigu Raj Maurya, on the topic of a jurisprudential analysis of adoption laws in India, with special reference to new criminal laws. Ms. Priyanka Kumari?
Chi. Good. Am I audible?
Yes, yes, yes.
Okay, sir. My name is Priyanka. Good afternoon, sir, and
Very
everything.
good afternoon. Very
My
good
name,
afternoon, Priyanka. Yes.
my
Welcome.
name is. Thank you, sir. My name is Priyanka Kumari, and I'm presenting the paper. My topic is a jurisprudential analysis of adoption laws in India. With this paper, focus on adoption laws which are governing the adoption in India and how UCC is necessary in the area of adoption, and is on the adoption laws with reference to new criminal laws. Basically, adoption is a legal process that transfer parental rights and responsibilities from the birth parents to adoptive parents. The purpose of adoption is to provide loving and stable home for the children and who need one, often due to circumstances where their birth parents are unable to care for them. According to Black's Law Dictionary, adoption is a juridical act creating between two persons certain relation purely civil of paternity and filiation. Adopted child is someone who is not the natural child of the parents but has become true child by legal action. Adoption of children is a socio-legal concept. It has existed in India and abroad since ancient times. It primarily means that a parent-child relationship was established where none existed. The child is one set of parents became the child of another set of parents as if it were a natural born child. Sajia Aman Khan versus State of Orissa and others, the Supreme Court distinguished between adoption, custody, and guardianship. Nothing that these concepts are not interchangeable. The court also emphasized the importance of the child's stability in custody matters, aligning with the Guardian and Wards Act 1890. The error in the High Court order may have occurred due to misreading or hasty framing. Adoption was viewed more as sacramental than a secular deed in Shastric Hindu law. According to some, adoption serves two purposes: to ensure that funeral rituals are performed and to maintain one's lineage. Hindu thought that if a person died without having a son, they would go to hell, and that the father could only be saved from hell by having a son. One of the justification of having a son was this. But the Hindu Adoption and Maintenance Act currently governs adoption under Hindu law. The Hindu Adoption and Maintenance Act only applies to Hindus who are described under Section 2 of the Act as anyone who identifies as a Hindu, including Buddhist, Jain, and Sikhs, as well as anyone else who is not Muslim, Christian, and Parsi and Jews. It is also includes a kid, legitimate or not, who has been raised as Hindu, Buddhist, and Jain. It is sorry, sir, sorry. This act extended to whole of hmm, having been abandoned and both parents or whose parentage is unknown. Only males could be adopted before this act, but it has now allowed for the adoption of females as well. This act extended the whole of India. My third chapter is International Convention and Covenants. India is a signatory to various international conventions, Parenting to Child and Children Welfare, Declaration on Social and Legal Principles relating to protection and welfare of children, with a special reference to foster placement and adoption nationally, internationally. The relevant article are as follows. In Article 3rd, the first priority of a child is to be cared for by his or her own parents. In Article 4, when care by the child is on parents unavailable or inappropriate, care by relatives of the child's parents, by another substitute foster or adoptive family, or if necessary by an inappropriate institution, should be considered. New criminal legislation impact on adoption laws in India. The primary subject of these criminal laws are the delineation of criminal acts and the procedure for their adjudication. While they do not directly alter the adoption regulations, they may indirectly influence their application for the overarching legal framework concerning child protection. The Indian Parliament has recently enacted 3 new criminal laws, including Bharatiya Nyaya Sanhita, which replaces the Indian Penal Code, and the Code 93 Code of Criminal Procedure has been supplemented by the Bharatiya Nagrik Suraksha Sanhita, and the Indian Evidence Act has been supplemented by the Bharatiya Sakshi Adhiniyam 2023. In my potential points of intersections is that crime against children, जैसे BNS encompass provisions related to crime against children, including as sexual offenses, kidnapping and abduction and other. And BNSS and PSA modify the admissibility of evidence, including digital evidence, along with the criminal procedure. And other crime reporting, the zero FIR provision in the new criminal laws allows the filing for a first information report at any police station, irrespective of jurisdiction, potentially facilitating and reporting of crimes related to unauthorized adoption or child exploitation during the adoption process, and possibly enhancing law enforcement response time. Protection of witnesses and victims, safeguarding witnesses and victims is an essential aspect of the new criminal code, and this may embolden vulnerable children or other aware of such offences to report them without fear, particularly in instances of exploitation during adoption process. Jurisprudential implications is that the passage of new criminal laws with pre-existing adoption regulations highlights how India's legal views on justice and child care are always evolving. Together with JJ's emphasis on children's rights, the shift in criminal laws towards a victim-centric paradigm suggests that the legal framework intended to protect children, especially those undergoing adoption, has been improved. The continued existence of separate legal framework for adoption, the JJ Act for everyone, and the Hindu Adoption and Maintenance Act for Hindus raise jurisprudential questions about the consistency and secular nature of law in a multicultural country like India. The JJ Act represents a more international and right-oriented viewpoint, whereas Hindu Marriage and Adoption Act, Hindu Adoption and Maintenance Act is based on personal laws and religious traditions. The interplay between these framework and the potential impact of the new criminal laws will continue to shape India's adoption jurisprudence. In the Constitution of India, the government of India is...
Please try to conclude, Priyanka. We are getting late.
Okay. Oh, sorry, sir.
No problem. You
Thank-
just go ahead. Go ahead.
Okay, sir. I would like the
Yes,
I would like
please.
to conclude that Hindu adoption rules have evolved, but there is a lack of a unified civil law in India that allows other communities to legally adopt children. A universal civil code would improve the social well-being of childless parents, guaranteeing children receive proper attention, security, and a bright future. Gender bias should not be determining factor in adoption. Private adoption continue in some hospitals and unregulated channels, and research on adoption is difficult due to lack of data. Indian culture does not often support open adoption, favoring closed adoption, which may cause a less trustworthy parent-child bond. Single parent adoption are legally permitted, but there is a limited information on their frequency and success. A uniform civil code will eliminate religious barriers and provide legal recognition to childless parents, ensuring that they can fully embrace their rights and responsibilities. Thank you, sir.
Okay, thank you very much, Priyanka, and all of you, all of presenters. 9 presenters has been presented their papers out of 11. Now, our eminent professor, Professor Satya Prakash, sir, will present his opinion on this matter. Please welcome, sir.
Okay. Thank you very much for inviting me to this conference and specifically to this technical session. I am audible?
Yes, sir, you are audible.
Okay. Okay, thank you very much for inviting me to this conference on criminal law and specifically to this fourth session of technical aspect where 11 presenters have been listed. Out of them, 9 presented themselves, and it is good to know that wherever there were co-authors also, so both of them could come to the screen and both of them presented their views. Actually, the theme of this session, I think, was special in the sense that it was different from the other technical sessions. It included the jurisprudential approach or jurisprudence behind new amendments. Actually, I should congratulate and appreciate the selection of this topic because it is generally the jurisprudential aspect is not considered, and we must be agreed with the basic fundamental principle that jurisprudence is the mother of law. So everything is being covered or governed or has direct or indirect connection with the jurisprudential approach. Unless you know about the nature of law, that is jurisprudence. Jurisprudence basically deals with the nature of law from various angles, right from ancient angle or historical angle, from anthropological angle to the modern sociological and the ought to be angle, that is the law, the science of legislation. So most of the presenters were having specific topics for their discussion and writing, and they have covered the topic they had selected, and it is also good to have various angles in the single session